repeated. Green is good, yellow, just like the traffic light, you're getting near the end, and red, you're at the end. So that's your total time on the clock.
Yes, sir.
All right, whenever you're ready, you may proceed.
May I please report? My name is Ryan Lee. I'm representing both Donna and Timothy Ruth in this case. This case comes to the court from a granting of a summary judgment on behalf of the defense. In this case, we believe that the trial court committed error in doing so. The short answer of why the trial court committed error in doing so is that there was plenty of evidence that the trial court had in front of it that not only proved Donna Ruth's claim, but also disproved what the defense, what Taco Bell was saying. And that didn't come just from Ms. Ruth's testimony, but it came from Taco Bell themselves, both with their employee testimony, as well as both corporate testimony and documents that Taco Bell did specifically.
Would this court's testimony been enough to defeat summary judgment by itself?
Ms. Ruth, I believe that no, and here's the reason why I say it. I think Ms. Ruth's testimony, the thing that Ms. Ruth's testimony would have lacked because she didn't have knowledge of it is how the water got there, right? So there are cases where someone will have slipped on water and the plaintiff has no idea how the water got there, can't prove that the establishment knew about it. It's just a random.
So the issue on the trial court was whether Taco Bell knew the floor was wet or had actual constructive knowledge that the floor was wet. You agree with that? That was the basis of the decision.
I do agree with that, and I think there's a couple of bases as well that the trial court did talk about, but the trial judge did hone in on this knowledge element, at least initially. I think at the end of the day, though, the trial court, what it did was there was evidence of actual knowledge. I think it's really undisputed. Taco Bell came in not only in their interrogatory answers, but also in their testimony of both corporate owner and employee, and said, we mopped the floor, and so we know that occurred. We also know that at least in the best case scenario, really to Taco Bell, that it was visibly mopped in the sense that you could visibly see it on the floor, and that the floor was either, depending upon whether you look at the incident report, the testimony, it was either slick, it was wet, there was water around a drain, things of that sort that would have shown that the bathroom where Miss Ruth slipped was still wet at the time.
Mr. Lee, so a question. So I believe you're referring to the testimony of witness Sterling. Is that correct?
Correct.
Okay, so from my calculation, and just want to make sure I'm not missing something here, Ms. Sterling's testimony was the mopping of the floor took place at least 30 minutes before she was notified of a fall, correct?
Yes, that is her best, I guess, estimate. She doesn't, so there's a little bit of back and forth on that in the evidence, because she certainly testifies that she believed that it was 30 minutes before. But then when you go to the interrogatory answers, and even Ms. Sterling herself, say that they don't keep any records of logs, they don't show when they do it. That's sort of their practice in doing it, but there's no one that can really sort of back that up. Now, it is the evidence, right? So it is that.
After Ms. Sterling was made aware of the fall, there was approximately 10 to 15 minutes that it took to prepare the report, and it was only after that 10 to 15 minutes that Ms. Sterling then went into the restroom and observed the floor, correct?
I don't believe it's clear as to when she incident report was done. Because there are parts of the incident report, because I mean, I think this was a fluid situation. I don't think she definitively says, I did everything in the incident report, and then I went in, and then I came out. I think she says that she got that Miss Ruth came and saw her, told her specifically, and then I think she said she grabbed the incident report and then went with Miss Ruth to the bathroom. And so I don't know whether there's this extra bit of time in doing the report. I would tend to think, at least the evidence supports that it's contemporaneously when she's going in with Miss Ruth and she's looking at the report, because some of the things that are there is her writing, her observation, right? She writes in the incident report the cause of it, and she's saying that the floor looks, she can see it, and it has that. I'm trying to remember the specific wording she uses, but she says in the incident report that the reason that the fall was there was because they had mocked it previously. And so I think that there's not a specific amount of time added on to even at least her 30 minutes. But certainly, you know, even if we were to conclude that, even if there was absolute evidence that said that, the evidence would then be that 30 minutes went by in the floor, Miss Ruth slips, she goes then and gets Miss Sterling. They come back 15 minutes later, and the evidence is clear, she still sees water. She doesn't say that she comes when she came into the bathroom, it was completely dry, I saw nothing. She doesn't say that. She says that now, I will say that there is a little bit of a difference between what she put in the incident report, which she filled out, and what she ultimately testified to. Because she does say that, well, I only saw water around the drain, and I saw maybe a little bit in the grout lines. That's not what she says in the incident report.
The whole question here really is whether there was enough to go to a jury on the case. Not who's going to win.
Right.
And it seemed like, in fairness to the trial judge, I think he maybe got a little caught up into who had the better case, really.
Yeah, I think so. I think so. And you know, look, I've had I've appealed many a trial judge to this court and other courts, and I think that, and especially when this was being done, because the trial court went into a lot of what we call the quote new standard, really it's new now. That does give the trial court, in all fairness, the ability to determine disputes of fact, rather than the previous summary judgment standard that basically said, almost, you have 300 witnesses that say, well, the light's red, and one witness that says it's green, and you're never getting summary judgment on that. It's not that now, but I do think that the trial court deviated away from even what the federal cases say in doing this, because there was a genuine, regardless of how you look at this, there was a genuine dispute of fact. And I actually believe, frankly, that the element that we started talking about, the knowledge, there was no dispute in the knowledge. They knew about it. Whether or not they were negligent in how they did it, whether they were negligent in where they put the sign and where it was in the hallway versus there, all of those types of things are not something that a trial judge has the ability to determine him or herself. It is something that they're sort of the gatekeepers, right? In just like a Daubert hearing or something along those lines. They have to find that there is at least some dispute there that a jury can properly determine. And those disputes were all over the place.
Between the incident report and Ms. Ruth's testimony, if you had nothing else and had the incident report properly authenticated, that's enough to have a trial over, isn't it?
Yes, it is. And add to that, obviously, because I hear her saying, obviously, you have to authenticate the incident report. I mean, Ms. Sterling's obviously testified she did. But even if we didn't have the incident report, we have interrogatory answers, sworn interrogatory answers, signed by the very owner that we deposed. That say the same thing, almost the same thing.
I mean, it's dispute in their interrogatory answers was whether it was damp or wet, correct?
Correct, right. But, you know, they say that, well, we don't think it was wet, but we also say that, and they were very clear in their public places to say that Ms. Roos was comparatively negligent because she should have saw that it was visibly mopped, right? I don't see how you can say that there's not water there when it's visibly mopped, at least according to their own testimony that's there. So, yes, we believe the trial court, whether the trial court ignored that evidence, whether he did what, you know, you're saying, Judge Edwards, and just said, I think that, you know, Taco Bell has a better case, and I think they're going to win. And then now I'm going to take the leap to say that no reasonable jury could find in favor of Ms. Ruth. I think that's where the trial court went wrong. Because it's not the trial court's, regardless of whether it's the old standard or the new standard, a trial court cannot weigh evidence at a summary judgment. And it's pretty clearly did in this case. So, unless there's any questions from the panel, I'm going to reserve the rest of my time for a vote.
All right.
Thank you.
Thank you.
Morning, may it please the court. Michael Monteverdi from Zenobia and Monteverdi on behalf of the area management doing business as Taco Bell. You know, I know also for today I use Taco Bell. I think that one of the things that Mr. Lee just mentioned, I think is really kind of where I want to start, which was, and I think the question was asked, would Ms. Ruth's testimony by itself have been sufficient to defeat somebody's judgment? And I think Mr. Lee quite clearly said no. And I think that that's really the issue here, because the question becomes, and I think that the appellant in the complaint and through the course of even the briefing in this case, in this appeal, has tried to hedge and has essentially said it's either actual knowledge or constructive knowledge, not really committing to either. And it becomes a problem there when you do that. You kind of work through the facts and you start working through the inferences that have to be relied upon to get to actual knowledge. And then the inconsistency if you try to work with constructive knowledge.
Mr. Monteverdi, I believe, did I pronounce that properly?
Sure, you did.
I think it's more complex than as simple as the testimony of Ms. Ruth, but my question would be, in the report, under the cause of the incident, your employee stated that the cause of the incident was wet floor from being just recently being mopped. Please explain to me how that statement in and of itself is not an admission of fault by your client.
And I'm glad you asked that, Your Honor, because that obviously, in going through the materials, is the first thing that jumped out at me, was the incident. But there's no indication that the incident report information is the information coming from the manager of the area. That information could easily, just as easily, be coming from the appellant. And in fact, as you delve deeper through the testimony, in fact, you realize that's in fact exactly what happened.
Why isn't that a question to the jury then?
Well, because I think it's demonstrative that that's not what happened. Because it's very clear from the undisputed record that it wasn't the information from the manager, but it was the information from the appellant. And I can explain how we know that. First of all, when the manager, I'll refer to as Kristen, I can't really explain her last name, but pronounce her last name.
Sterling or different?
Sorry?
Talking about Miss Sterling or something?
Yeah, Miss Sterling. Yes, Sterling. Yes, Miss Sterling. When Miss Sterling's, when she was deposed, she was asked with respect to the incident report, how was it filled out? She said, I sat down with the appellant, I took her information, filled it out, and then I went and checked the bathroom after she left. Now, Mr. Lee said there was no indication within the record as to whether or not the incident report was prepared before or after, but there was. In fact, within the record, page 536, in fact, she says that what she did first was she sat down when it was reported. She completed the incident report, and that's where she explained that she would have first gone into the bathroom to check 10 to 15 minutes later, because that's what was after. She was asked, did you go to the bathroom before or after the incident report was completed? She said after. On page 548 of the record, she said that she took down the information from the appellant when she was completing the incident report. And then she left.
The floor was still wet then, correct?
Well, when she went in, what she said that when she went inside, she said she checked the floor, that it was not wet, but that there was an area that was slightly damp around the drain. Now, here's where the issue becomes. Nobody has been able to say whether or not the floor was wet because it had been dry mopped, because that's the other issue.
Well, how should dry mop something?
I'm sorry?
According to your CEO, you have to wet the mop, correct?
You do, but according to all of the testimony, the dry mopping is done purposefully before the customers arrive and before the store opens at 10 a.m.
If you're dry mopping something, why do you put out a wet floor sign?
No, I'm not suggesting that there was no dampness or wetness on the floor. That's not what I'm suggesting. What I'm suggesting is when they go through the process of dry mopping, they explain it. They say you don't even bring the bucket back in. You put the mop into the water, you take it out and you wring it, and they explain it very precisely. You wring it out 3 times, and you make sure that it's relatively not dry, obviously, but that it's damp and that it does not create any puddles of water. They also
Record 542, when Ms. Sterling is asked, were there ever any instances when somebody doesn't strain it all 3 times they're supposed to? Cleaning captain's the only one who does it, so I don't think so. I wouldn't really know, to be honest, because, I mean, you wouldn't expect the manager to follow the guy around as he mopped, but was there any evidence of any kind that water was on the floor from any other source other than mopping?
no, but that is the burden of the plaintiff. The burden of the plaintiff is to establish.
Well, the defendant admitted in their answers to interrogatories that they recently mopped the floor.
Well, what they said was that the floor was visibly mopped, but then they later
What does
said.
that mean?
It means that, well, it can mean a number of things, because they later
Is
said.
it for the jury to decide?
Well, I don't think so, because later in the interrogatories, what they say is they also say that the floor was not wet, and they dispute the issue of the floor being wet. And here's where I think the issue
Why isn't
comes.
that an issue of fact? They admit that they say it's damp, plaintiffs say it's wet. If damp versus wet matters, who gets to decide that?
Because I think that the problem here is that nobody can say that that's what the plaintiff said. The plaintiff can't, the appellant can't even say that that's what she said. She did not describe it in any way, shape, or form. What she said was, she said, I walked into a bathroom, I slipped. When I was on the floor, it was extremely wet. Okay? Now, these are the inferences that you have to stack to allow that. And juries are not allowed to rely on stacking inferences. We have a case on that's good. They're allowed to make a mistake.
How is that an inference?
No, I'm going to go through the inferences. The inferences that you have to rely upon to get the issue of actual knowledge, because now we're talking actual.
Did the defendant argue in its motion for summary judgment that there was no evidence of how the water got on the floor?
Yes, they said that the plaintiff, they said that the appellant did not establish what she slipped on or how it happened. And here's where the stacking of inferences, here's how you get to the stacking of
When you
inferences.
say how it happened, how she fell?
What she fell on. And that's what the trial court said. The trial court said that she did, and the trial court on page 38 of the appellant's brief, they cite, or page 32 of the appellant's brief, they actually cite to a very important point, and they reference a very important point of the trial court's summary judgment order, which is the trial court identified the problem here. The trial court said, look, you're either saying it's constructive notice, and if it's constructive notice, it's got to be constructive notice of something that you are not actually aware of. Right? But that's not really what they're saying. Now, really, the appellant is kind of saying that, because the appellant at no point in time herself has ever said, I fell on water from my mom. She never said that. She said, I walked in, I slipped. It was extremely wet, and there was water on my pants, and there was water on my coat. That's what she has said. She has never said, I fell on water from my mom. Now, if the position that the appellant is going to take is that it's a constructive knowledge case, well, then it's not the water from the mop, because the water from the mop would be an actual knowledge case, because of course, my client had actual knowledge that they mopped the floor. So now you
Defense at one point almost seems to say, with the 30 minutes and the different time frames and all the rest of that, that even though we damp mopped it, dry mopped it, whatever mop you want to call it, that it would have dried up by then. And the judge even refers to by then it should have dried up. So I think that perhaps, that's how I read the constructive knowledge aspect from the defense, that we didn't know it was still wet.
well, I think on page,
I thought there was that in there. If I'm missing or adding something that wasn't there, I apologize, but I kind of got that flavor.
no, I think that is maybe a somewhat reasonable place to get to, but I'm not necessarily sure that is what is being said. And I would say, you raise another point on page 541 of the record, Ms. Sterling says that after the dry mopping is done, it should be 100% dry by the time that the customers come in.
In the front lobby.
Yeah, so it's 100% dry in the
That's where
lobby.
they start.
Yeah,
So
so,
start there and work their way back to the bathroom.
yeah, and that's why they put the wet side right outside the hallway that goes into the bathroom as noted in the photographs, which is right outside. Is that area?
Yeah, it's one of these tent ones like that, and Ms. Ruth testified as she came into the door, it was like this facing her, not like this facing her. So if she had looked at it, she probably could have seen it, but she had to go to the bathroom, right?
Yes, I agree. But she said she didn't even see it, right? That's what she said, even though it was right there. So I think that this is the issue. So I think that for a second, I'm just going to jump to the issue of actual knowledge, because I think that that's what they're actually saying. At least that's what they're trying to say. What they're saying is you mopped the floor, therefore you knew that the floor was wet. And Ms. Ruth walked in, slipped and fell, and therefore because you knew it was wet, you are now responsible. Right? Now, number one, it ignores the fact, which I'll get to at the end, that there was a warning sign there, and just because it's not a warning sign that she noticed or appreciated does not mean that they did not warn her, but they did. There was a warning sign there in the area where it was locked. But here's where you have to get to believe that story. And for a jury, then has to stack the following inferences. And the first reasonable inference is that a floor would be wet if you mopped it, even if you dry mopped it. Judge Bowman, as you just correctly pointed out, a dry mop is not dry, it is damp, right? So that is the first reasonable inference that you can make, and it is permissible to make that inference. And a jury can easily sit there and say, if you mop the bathroom floor, it is reasonable to infer that it is going to be damp or wet. But now what is the next inference you have to make? The next inference you have to get to is that it remained wet that entire time and did not dry over the course of an hour and a half to 30 minutes, sometime in that time period. They said that they usually do it around 9 a.m. She slipped and fell at 10:30. She didn't slip and fall when they first opened. She slipped and fell at 10:30. They say they normally dry up at around 9 a.m. so that it will be dry before it opens at 10. The next inference you have to come to is that she walked the entire hallway that was also locked at the exact same time, which the undisputed evidence demonstrates, and then none of that was wet. None of that area was wet. She didn't appreciate that it was wet, and it's the same exact tile floor that exists in the bathroom. Then you have to infer that she went into the bathroom and slipped on a floor that is extremely wet, which is what she said. But that 10 minutes later, when Ms. Sterling goes into the bathroom and looks, it is now only damp around the drain and that it is dry. And you also have to infer that nobody from 10 a.m. until 10:30 went into that bathroom and washed their hands and got water on the floor. Walked in with a drink in their hand and spilled water on the floor. Walked in with a drink in their hand that had water condensating off the side and dripped on the floor. That multiple people didn't wash their hands and dripped water all over the floor. That's the next inference. The next difference is you have to believe that the floor would have been dry by the time Ms. Sterling took the photographs, because not only did she say that it wasn't wet and that it was damp, but the trial court relied upon the photographs, which showed that there was not excessive water on the floor as testified to by Ms. Ruth. And that is the only way you can get to a place to say that Ms. Ruth can, in any way, shape, or form, demonstrate that she slipped on water that came from a dry mop that was done at least a half hour, maybe up to an hour and a half before she even entered the bathroom.
Was there any testimony about the procedure that was followed as far as how long after the floor was mopped that the sign was removed from the floor?
There was not, but there was testimony that said that the reason the sign was placed where it was placed was two reasons. The first one was they said it was a little bit broken, so they had to lean it up against the wall. That was the first reason. You know, that is not, I guess, neither here nor there for my opinion. But the second reason they say is actually very important. They say we generally would put the sign in the area that is the most wet. So the area that is the most wet is the area where the sign is. An area that was mopped at the exact same time that the bathroom was mopped, but was dry. Ms. Ruth did not testify that that area was wet when she walked in. She did not testify that it was wet when she walked out. At no point in time has she said the area that was the most wet was wet. All she said was that she walked into a bathroom, slipped on a slippery surface. She didn't say that it was mop water. She has no idea what it was. In fact, I think as everybody sits here today, nobody actually can say, the appellant nor anyone else can say, you know what, she slipped on the mop.
Is it reasonable to infer that if you take take for granted the testimony of Ms. Sterling that when she came into the restroom, she observed there were still areas of the floor that were damp, is it reasonable to infer that at any time prior to that, the floor of the bathroom could have been damp and or wet
I think it is.
prior to, between that time frame and the time that Ms. Ruth fell?
Well, remember, Ms. Sterling went in after Ms. Ruth fell. As she testified, she said she took the incident report, and then the first time she went in to check the floor was after. And she said when she went in, it was dry except for the area that was damp around the drain. And your question is it reasonable to infer that it could have been wet before she went and checked the drain? Of course, but from what?
Well, that sounds to me, counsel, like you're arguing it's a rebuttable presumption or a rebuttable inference, correct?
No, I think what I'm arguing is that in order to even get to a place to say that a reasonable jury could infer that Ms. Ruth definitively, or by the greater weight of the evidence, fell on the mop water, you have to then start stacking inferences. The Public versus Balash case specifically says, if a jury is required to rely on the stacking of inferences to establish notice, directed verdict, right? Same standard now as the summary judgment, directed verdict should be entered. Juries are not allowed to do that. That's the only way that they can reach the conclusion that the appellate wants them to reach. The only way that you can believe, or you can get to the point where you are reasonably inferring or concluding that she slipped on mop water, is to say, we know that it was bottles. Reasonable inference number one. Now we're inferring that it didn't dry. Now we're inferring that everywhere else dried, but that place didn't dry. And now we're inferring that it dried, except for this little area around the drain, in the 10 to 15 minutes between when the incident report was filled out and when Ms. Sterling went in and took the photographs, which also showed it was dry. And during that entire period, it went extremely wet, right? Not damp, extremely wet, according to Ms. Ruth. And then went to dry within 15 minutes. And by the way, you also then have to take Ms. Ruth's own testimony and demonstrate that it actually suggests a different causal. Because if a dry mop is supposed to be something that does not create causal, and does not create extreme wetness, because you know that you are mopping it on an area that is going to be traversed by customers. And the whole purpose of doing it before opening is so that it dries in time for them to be there. And when she said she slips in, it's extremely wet, and her clothes get wet. It suggests another cause.
Ms. Sterling said in her deposition that as far as mopping, it had to be in the morning because we didn't want customers to get injured.
Yeah.
So if you walk on a floor that had been mopped, Ms. Sterling says there's a chance that customers could be injured even with the dry mop.
Agreed 100%, and that is why I do disagree with that. That's why, because it is wet, but that's the whole reason why she says we do it before the store opens. Remember, they testified, the store does not open until 10.
Right, you start in the lobby and work your way back. But I do know where I got the idea that the constructive notice issue was that the defendant did not know that the floors were still wet. That's what your motion for summary judgment on page 10. So even if this court were to accept Ms. Ruth's position that the tile grout lines were wet, there's no evidence that the defendant knew they were still wet. Now, if you pour a bucket of water on something, is it really up to the plaintiff to prove that you knew it was still wet? I know you didn't pour a bucket of water, but...
No, but I do think it is up to the plaintiff to prove that they slipped on the water that came out of the bucket of water.
I got you.
And that is something that cannot be done. It cannot be done without stacking the inferences because there is nothing to suggest other than literally say, to get to the place where a jury concludes and says, we, based on the evidence that is there, the evidence that's in the record, the only way that they can conclude that Ms. Ruth slipped on water that came from a dry mop is to go down that road that I just went, which is dry mopping is done. It's done before the store's open. It's done at least 30 minutes before she's there, likely more, an hour and a half, since Mr. Owens said it usually starts at 9 a.m. Then you have to conclude, then they would have to infer and conclude that everywhere else dried. Everywhere else was not dry. Even the area where they put the sign that still goes damp, that dried. She didn't notice any water on the floor. She didn't slip on the same exact tile that's in the hallway as that in the bathroom. Then you have to be able to infer that when she walked into the bathroom, for some reason that floor was still wet. you have to then exclude any other possibility. Nothing else could have caused that water to get on the floor. It has to be the mop.
In terms of the jury instruction, would it be more likely than not that that's what she fell on, or to the exclusion of everything else?
Well, I think it would be the greater way to the evidence, right? But I
More
think,
likely than not.
yes, but the problem is the only way you can get there based on the record evidence is to make all of these inferences. You can't get there any other way. There's no testimony that somebody went in 2 minutes beforehand and said, hey, you know what, when I think his name was Wilfredo went in and mopped it, it's still wet. There's no mop there, leaving water on the floor. Nobody had gone in periodically and said, man, the floor's still not dry. But the testimony is that everywhere else is dry. And then you
What did Mr. Erling mean by saying that the floor was, or the, I guess the affirmative defense is that the floor was clearly mopped or obviously mopped, whatever the words were?
She said it was a visibly mopped floor. Right?
What does that mean?
You know, look, choice of language in interrogatory sometimes, I guess, can be problematic, right? But if you look at what the consistent statement was, it says it was a visibly mopped floor. Meaning, it's obviously a clean floor. Obviously, there's a sign that's sitting there that's saying it's been mopped.
But wet floor.
But then it said, well, yeah, it wasn't.
It says wet floor.
100%. Well, I don't know what the sign says.
And it's still on the floor.
It's still on the floor. The floor is not wet. And in the interrogatory answer sworn
Well,
to say,
that's an inference that you're making that the floor is not wet. The sign was actually not based upon your client's protocol. It was not where, if they followed your protocol, where the last mopping would have taken place.
that wasn't what they said the protocol. It said the place where it was the most damp. So she said it would have been placed there because that would have been the area that was the most wet.
If they mopped both they only mopped one, they put it in the bathroom. If they mopped both bathrooms, they put it out the front. Right?
Well, they only had one sign. But here's the issue, and I just want to
I'm not
address
getting into subsequent remedial repairs.
And my time is up, but
Go ahead.
I just want to address the one last point, which is the issue of, and I forget what you just asked me. You said about the
Well, you signed what under oath, I guess.
yes, under oath. They specifically also. So you said, "Are I inferring that it was dry?" No, I'm not inferring it's dry. That's what the testimony was. The testimony was that everywhere else was dry. That the only area that was slightly damp was around the drain. And again, you view the record evidence in the light even most favorable to Ms. Wood. The best you get to is there was some water or wet substance on the floor. You cannot get to the fact that it came from a mop or a dry mop unless you go down that whole road and just exclude the fact that there are a ton of other reasons why there could have been water on the floor between 10 a.m. when they opened and 10:30 a.m. when she slept there. Thank you.
Counsel for the Ruths.
Yes, sir. So there's been a lot of argument about Ms. Sterling, about what she said and how she said it. There's one piece of evidence that we haven't talked about, and that is Ms. Ruth's testimony. She talked about the aftermath of the fall, going to get Ms. Sterling, bringing her back in the bathroom. And here's what she says. This is at page 444 of the record. She says, do you remember any comments or statements that this female manager, we know that to be Ms. Sterling, made to you? Answer, she stated that the floor had just been mopped, that whoever had done it had failed to dry mop it, and that there was, in her opinion, an excessive amount of water on the floor. Now, that's Ms. Ruth talking about what Ms. Sterling told her. It's hearsay, but there's an exception to it. It's an admission of a party opponent. That is something that, for all intents and purposes, is going to go in front of a jury at trial, and it is Ms. Sterling saying, I'm looking at the floor, and there's an excessive amount of water on the floor, and that they didn't dry mop it. That's what the evidence shows. Now, regardless of whether Ms. Sterling later says, well, I think it was done 30 minutes before, without any logs, by the way, of when it actually was done, or that I think that it was maybe damp, or maybe it was just wet around the grout lines. We have this evidence from Ms. Ruth. The jury should be able to take both sides and to determine that genuine dispute. Just on that. Obviously, obviously there's other evidence that's there, and we've gone through some of that evidence, but at the end of the day, trial courts, even under now the standard we have, cannot weigh evidence. They can't say what version of the evidence, or even if you take the defense argument of an inference, what inference they think is the right one. That's not something the trial courts can do. The trial court did it in this case, and unfortunately committed error. This court should reverse. Thank you.
Thank you very much. We'll be in recess. Take a quick break. We'll come back in.